speaking with me, Tarun Nangia. A bench of justices, Justice Hema Kohli and Justice Ehsanuddin Amanullah, came down heavily on yoga teacher and businessman Ramdev for especially making false claims with in relation to cures that the medicines manufactured by Patanjali offer. Also, they came down heavily on making false claims with regards to diseases of heart, also some claims on corona. There were also statements they may have regarding the efficacy of allopathic medicines. And they virtually ran a campaign on the vaccine issue also. All of that the court noted. The court also refused to accept the apology tendered by Ramdev and has asked Baba Ramdev and also Acharya Balkrishna to be present on April 10th, which is the next date of hearing. So some serious comments made by the Supreme Court, and of course not without a reason. What those reasons are, my panel will tell me. Let me welcome senior partner of Saraf and Partners, Vaibhav Kakkad. Good to see you, Vaibhav, and looking for some interesting insights.
Thanks, sir. Always a pleasure to be on your show.
And Malak Bhatt joins me. Malak is founding partner of NM Law Shops, a very successful litigation law firm. Good to see you, Mr. Bhatt. Looking for some interesting insights from you as well. At the outset, Vaibhav, could you, in about 2 minutes or so, share some details from the industry point of view, the pharma companies, the companies who are running hospitals, and for more reasons than one, many times a lot of people advocating traditional medicines can be seen in these very hospitals getting treated. But I leave that to you, your opinion.
Yeah, thanks, Tarun, once again for having me on the show. I think, look, the way one has to assess this issue is that there is a specific law of the land, and that law has been around for quite some time. It's the Drug and Magic Remedies Objectionable Advertisements Act of 1954. And that statute is pretty explicit in terms of what it seeks to prohibit. What it prohibits is any advertising undertaken with respect to any product or any drug that you advertise to the public at large, which seeks to suggest that that a certain disease or a certain kind of ailment can be cured or mitigated or addressed by consumption of those products and drugs. And that statute has been in the law books for forever. Unfortunately, the enforcement of this statute hasn't been as strong as it ought to be. And if you actually look at the schedule to the Act in terms of the kind of diseases that it seeks to prohibit any advertisements or misselling for, it is a pretty exhaustive list. It would cover all of those typical lifestyle ailments such as diabetes to blood pressure to asthma to AIDS. It covers all range of medical ailments. And unfortunately, Tarun, what's happened is that over a period of time, we've seen multiple companies coming up with advertisements offering alternative forms of treatment and cure, and often unsubstantiated. This particular matter of Patanjali is sub judice, so I don't want to specifically comment on their practices. But of course, there are some companies, including Patanjali, that have in recent times made quite a fortune by selling products and various kinds of services premised on the basis that a lot of these ailments can be mitigated or addressed. And I think that goes to the very root of the issue, that how much of, just like how when a new medicine is launched, there is a detailed framework under the Drugs and Cosmetics Act. There are medical trials that are undertaken. There is an entire regulatory body that certifies the efficacy of drugs after trials that those medicines go through. There's a substantial expenditure companies incur. There's a massive, R&D that one sort of supports for these kind of new introduction of medicines. Unfortunately, for alternative medicines, there is no such standard. And if organizations have big advertisement budgets, and then you conflate that with a little bit of spirituality, you can actually run amok amongst public at large. And I think that's what's transpired, or that's the issue at large. And I'm glad that it's ultimately sort of seeing some light at the end of the tunnel in terms of enforcement. This should not be the only case or only scenario where you see effective enforcement of this law. This law should be enforced against all and sundry. But obviously, you start somewhere, and I think now the Supreme Court is specifically concerned about acting against this one particular instance. I think one is the issue of alleged violation of the act, and I'll just end it here. But the other issue is how the government has been so far acting on this issue. What Ayush Ministry has done, what the government's position on the mis-selling or misstatements and these advertisements has been, and what the government has done. I think the court does believe that perhaps the government has not played as active a role as it ought to have been. So one is the issue of somebody violating the law and somebody being held responsible for doing so. And the other is the piece of what the government has done with regard to it. And I think both are as important pieces too.
Point well taken. Point well taken, Vaibhav. I'll go to Malak Bhatt, founding partner of NM Law Chambers. Malak, what do you see happening and playing out in the Supreme Court? The Supreme Court seems to have taken a pretty stern stance. In fact, they also warned Baba Ramdev of committing perjury by submitting backdated documents. Do you think the Supreme Court has a reason to be angry, and so angry that they have been summoned and they have been summoned again? What has played out?
Yeah, so in fact, Vaibhav touched upon the most critical part of this talk, which is the violation of the existing law. I want to cover two other issues which are the backbone of the Supreme Court's hearing. Obviously, one part and the majority part of the way the hearing is taken place is the fact that the advertisements being put out by Patanjali are not advertisements which effectively only show their product, but are also trying to portray or misportray the fact that the drugs which are being produced by Patanjali are actually curing a disease. Now, as you know that in general pharmaceutical parlance, there is never an effective cure to a disease. There is only the degree of efficacy of a drug which helps in reducing the impact of, especially in cases of viral infection. So if you look at the case of Corona, and in fact that was the biggest backbone of the entire way the Supreme Court hearing took place, Patanjali was advertising that Coronil to an extent was trying to cure the entire viral infection completely, whereas that has never been the case with any of the vaccines which came in place after a series of trials and reruns through the entire discourse of the virus. But the second part which the Supreme Court was really concerned with and which really hit hard at the hearing was that not only were they advertising or misportraying information regarding their own products, but they were also disparaging allopathic medicines by saying that they are absolutely inefficacious and they do not cure diseases at all. Now, one thing which caught the Supreme Court's mind over here was, if you look at the manner in which drugs, cosmetics are regulated in India as compared to alternate medicine, you have the Drug and Licensing Department, you have the Director General of Drugs who are actually conducting a systematic survey, and there's an entire regime in place for bringing drugs into the market before they're actually put into the public use. As compared to that, on the other side, you have Ayush, which practically takes care of all your alternate forms of medicine, which is Ayurveda, Unani, Sushruta, homeopathy, everything but that control, that regime is only for the purpose to a large extent for admission into colleges or regulating the course structure for these universities. There's no really effective mechanism of how the drug is to be brought into the public use. In that context, the Supreme Court saw that obviously you're spreading misinformation, but at the same time, you are trying to create an imbalance in the public mind to say that you cannot use conventional allopathic medicine because they are not going to help you. And that, in fact, was the backbone of the entire case of perjury, that if you made a statement which goes against the statutory framework of the way in which the country is functioning, of the way in which conventional medicines are functioning, then obviously you are causing haywire in the public sphere of information regarding these pharmaceutical drugs. Because as we all know, it's the common person is not going to look at the actual medicinal combination or composition of the drug. Is going to go by generic advertisements or generic information being put out. So for someone like that, and using a public figure who has been in the market, propagating yoga, and who's been doing this exercise to say that it's one of the healthier forms of living beings and living structures in the country. To then go and say that allopathy is not going to help you at all is a very big statement, which is hitting hard at the common man, and which I think has been a core issue that the Supreme Court is trying to address. The interesting fact to that, to add to that, and to answer your question as to where the Supreme Court would really go with this, is in most contempt matters, we've seen that the Supreme Court accepts an unconditional apology and lets the matter end there with the contempt being purged. The fact that the Supreme Court said, I'm not accepting your apology and I'll take this to a logical end, shows that it is really concerned with the way in which this action of Patanjali has hit the mindset of the common person. And that, I think, is going to be the crucial factor in the next hearing.
Point well taken, Mr. Bhatt. I take this to Vaibhav Kakkad, senior partner with Saraf and Partners. Mr. Kakkad, you work with a lot of pharma companies in your line of work as a lawyer and also with hospital groups. They have been sort of involved in this matter. The medical council is involved, obviously. When you attack the very edifice of the structure of the allopathic medicine industry, which has successfully performed, and at the cost, then promote your own products, for which they may or may not be, in the say, I mean, show that they have things. What does that lead to? Because it shakes the confidence of these very companies who have delivered India, for not any reason, is the generic medicine capital of the world. We export to the world. We have a large industry as far as allopathy is concerned. Could you, in a nutshell, give me a bird's eye view of what is playing out here? Is the court cracking down on a certain kind of promotion where a large amounts of Indians who are influenced by somebody like Baba Ramdev give up allopathy and then blindly subscribe to the medicine which he is selling, which may or may not have the efficacy or the trials that normally one has to undergo? Maybe there are no published trials and results. Could you give me a bird's eye view of the situation that is developing in the courts?
That's right. I think it's a very fair question that you're asking, Tarun, and a very fair sort of assessment of the issue. I think the way I see it is that the ultimate issue boils down to the commerce of it, the commercial aspect of it. One is a finer technical point. I do want to call that out. I think Malak's made a good point, and it's a very valid one, that I think the disparagement to the allopathic form of medicine is what really caught the ire of the court. But be that as it may, if you actually look at the statute, whether there is disparagement or whether there is no disparagement to allopathic form of medicine, the core issue really remains that whether you are promoting or advertising products aimed at the masses with the impression that those drugs or products will mitigate or address certain kind of diseases. Now, this has been in the law books forever. But the commerce of it is now playing out in the courts, which is essentially that, look, ultimately, as I mentioned in the opening remark, pharmaceutical companies are investing millions of dollars in R&D. And as Malak also rightly pointed out, there's a very detailed licensing framework. It's to when you launch a new product, a new drug, and when you suggest that it can have certain kind of efficacy against certain kind of issues, it has to undergo a certain amount of scrutiny by various medical council organizations, agencies within the government. And only after years of trials can you actually put out a drug and be able to sell it. Similarly, medical treatments, they all have to undergo a certain degree of scrutiny. And there's a huge amount of capital that's involved, both when it comes to private healthcare, even for that matter, public healthcare. Now, suddenly, when you come up with these kind of claims, and unfortunately, these claims are being backed by those individuals who anyways have a large public persona. And I said, you add an element of spirituality and a little bit of religion and all of that to it, then it just gets into tricky waters where suddenly every word is treated as gospel. The issue of what transpired with Coronel, Tarun, without getting into specifics, I was reading some independent data which said that about 250 crores worth Coronel medicines got sold during the COVID time period. ultimately, and those claims that were made in the presence of very senior functionaries of the government. Ultimately, Ayush as a ministry said that it can be used as an aid, as a supplement, but in that time period, as a supplement to boost immunity, but certainly is not a substitute for vaccination program. I dare say what was the kind of actual loss that the public suffered because people did not in that time period who consumed those 250 crores worth coronal, did not actually, take vaccines, or the kind of medical complications they may have endured because they perhaps were not following the right treatment and the right cause. I think those kind of issues in this country need to eventually play out. It's not just a question of a submission of an apology or a perjury. Those are aspects which I'm sure with the right counsels in the court, you'll be able to deal with it effectively. But I think the larger issue really remains, and I think maybe, every time something wrong happens, you have to make an example and then follow through. What I'm really hoping for is that the discourse goes wider beyond Patanjali, goes beyond, because you and I would have seen hundreds of ads in newspapers every day. But of course, the one that actually assumes importance and becomes a bigger name is the one who gets targeted. So if they have committed violation of law, I think they should definitely be penalized for it. But similarly, then action needs to follow through on ground. I do want to bring it to the attention of the audience through you, Tarun, that ASCI, the Advertisement Standard Council of India, which is a self-regulatory body, they have been issuing orders after orders against Patanjali forever, saying that a lot of claims that they make qua their products are completely false. ASCI had entered into an MOU in 2017 with Ayush Ministry, which very clearly called out that ASCI will immediately report to Ayush Ministry wherever a particular product has been, which falls within the jurisdiction of Ayush, has oversold itself or overstated itself and made misleading advertisements. But and those products are still running amok. But I don't think pursuant to the MOU, active enforcement has happened. I think that needs to start happening because, of course, ASCI's hands are, clipped in the sense that it's just a self-regulatory body. ASCI has been passing orders by the dozen against Patanjali, but nothing really transpired. So I think Ayush and ASCI's data suggests that if you look at misleading advertisements, alternative forms of medicines is the third highest forms of misleading advertisements that ASCI has to confront with on a daily basis. So I think Ayush as a ministry and other ministries within the government need to now play a far more stronger role in effectively curbing these practices. Because ultimately, it's not just a question of a written apology or a perjury. It's a question of the kind of loss that public suffers each time they consume these drugs or these medicines at the cost of allopathic medicines. And I think the larger point is that once somebody gets trapped for a misleading advertisement under the Drugs Magical Remedies Act, it also constitutes a misleading advertisement under COPRA, under the Consumer Protection Law. So I have a feeling that if this issue does not get addressed effectively and there's not effective enforcement, consumers and consumer associations will now be forced to go and make large compensations for the actual losses that have been caused to them for consumption of these alternative medicines.
It's an interesting comment you made here. I'll take this ahead with Malak Bhatt from NM Law Chambers. Malak, if a claim is made by somebody having a big status in society who people follow, a large number of people, gullible, will buy those medicines. On one side, there is thousands of crores worth of business being generated. Secondly, there is a cost to health. People suffer. Do you think the court has now taken the bull by the horns in this case, where they are going after the biggest player because they do the biggest harm? If they were doing good to society, it was nice, but making false claim about curing serious diseases is a societal danger, don't you think so?
In fact, it's one of the reasons why the court has taken this up to probably set an example for the, and this, according to me, was the court's lowest hanging fruit, because Patanjali, as we all know, is a name which was generally common across households, because the way their branding and the marketing started was with household products. So they used to initially product natural turmeric, natural a material which you would generally use in your daily supplements, foods, etc. So it became a connotation for using something which was in quote unquote natural for the human body. Now, what happens with that kind of a situation is that once the general mass thinks that this is a brand which otherwise is making substances or making material which is, if not harmful, if not helpful, at least not harmful for the body, they see it as something which can be integrated within your daily discourse. With that in mind, when the same entity comes out with it, with an advertisement or with a proliferation of an idea that, look, I am now going to get into the space of medicinal products which are going to effectively do much better for you than the normal allopathic medicine, it kind of hits at the desperation of the general public that, okay, fine, the allopathic medicine is anyway there is a price mechanism which it goes through, and therefore the goods are probably priced at a particular point. So for an industry like Patanjali, which was anyway making a lot of money, to hit a lower price point and enter this market by saying this is an effective remedy, an alternate effective remedy to something which is already existing, actually hit the desperation of the public at large. And to bring it at a time where the country was facing a pandemic situation, and to say this is a great alternative, because ultimately what they were trying to really try and trigger was the placebo effect. As we all know, generally in the medicinal industry, you've heard that if you take some medicine, you will get better, and that probably was what really Patanjali was trying to target. Interestingly, in the hearing, the placebo effect was raised by the IMA. The counsel for the IMA said that this is exactly what the trigger point is, and that's what you'll have to address. So yes, I think the court really has hit the target absolutely right. In fact, Weber raised a very interesting point. So the core argument of the IMA here is that this is not really only a violation of the Drugs and Magical Remedies Act, but you'll also have to bring in the Consumer Protection Act. So in fact, the prayer is to rope in the CCPA, which is a body under the 2019 Act, to try and take action. Because what happened under the Magical Remedies Prohibition Act is that the only penalty is by way of imprisonment. But what happens if you bring in a company who today will say, very well, I have a signatory here, I have someone who will go into prison for 6 months and come out. They've brought in the CCPA to remedy the situation that a company which otherwise has thousands of crores in its coffer cannot go scot-free by actually trying to defraud public at large and say that this is the end of the matter. So to bring in in fact the more important part is that every time we see a new legislation come up, if the agency is not, or the regulatory body under that act is not tightened at the right initial times, then it kind of dwindles down. To bring in the CCPA, which is under the 2019 Act, it's only been 4 years since the CCPA has come in. To bring them in and say that, look, you really have a robust role to protect the faith of the public and to protect consumer interest at large, is going to be a very, I would say, pivotal moment in the way in which this hearing takes place, because I see this going forward to show that this is a case where the CCPA also will have to step up and ensure that they take actions either in the preventive or prohibitory framework to ensure that such misleading advertisements or misleading information is not spread by companies in future. Tarun, you're on mute, I think.
Tarun, you're on mute.
Thank you, Malak. I'll take this forward to Weber Kakkar, Senior Partner of Sarafin Partners. Weber, we are looking at an industry size today of 5,40,000 crore rupees. An industry which Piyush Goyal, the Commerce Minister, said in 2022-23, we witnessed a 2.7% rise in pharma exports. The world trusts Indian pharma. That's why we are able to export so much. The government says that the pharma industry exports will rise to something like 11 lakh crores. If that is possible in the next 7 years, of course, the world trusts India with making medicines. Do you think at this time when certain famous people misuse that and start hammering out the Indian pharma industry and hospitals, it is like we are damaging our own industry? Do you think that is also a worry here?
Partly, yes, Tarun. I mean, I wouldn't go as far as saying that both these issues are joined at hip. Perhaps they're not, but they do have a correlation, because ultimately, a large number of these pharma companies, have a big market domestically. And, ultimately, if you look at a very macro level, Indian economy, the way it's growing, and particularly the pharmaceutical industry, is also because we have a large domestic market. And that's sort of driving the growth because the global cycles keep changing every now and then. But the domestic market consumption has largely driven our growth for overall the industry. And to that extent, obviously, practices such as these need to be curbed. I mean, goes without saying. Specifically, without getting into too much details of the merits of this particular litigation, I'm quite amused looking at some of those advertisements, which got actually printed after the date of giving assurances before the court that they will henceforth not come up with any misleading ads. So it puzzles me as to what kind of legal advice they got that got them to actually come up with these kind of claims after giving written assurances in court. But I think, like I said, I think we should not restrict ourselves to this specific issue. I think it's a larger point to be made. Yes, I think the allopathic, as the Solicitor General, Mr. Tushar Mehta, said in the court that, look, there can be criticism to allopathic form of medicine, and I don't think the industry has a problem with that. Of course,
I want to hold you there, Weber. Will I be right when I say that I am in very good to criticize, say, vaccines, but criticizing vaccines and saying, okay, buy my medicine, the vaccines are bad. So I am directly benefiting from my action. Do you think that's where the problem lies?
Absolutely. The problem is that you're promoting alternative forms which have really not been tested, scrutinized. There's been no validation. There's been no trials that have been done. Ultimately, if you remember, many companies, pharmaceutical companies globally, did try and come up with their own version of vaccines. And they'd spend millions and billions of dollars, but unfortunately, they could not stand the test of scrutiny. And I think just because of a certain allegiance to a certain form of treatment that the country generally culturally has found it close to their heart, doesn't necessarily mean that they're all valid. And I think that's what needs to be addressed. And as Malak rightly said, criminal sanction under a statute, I don't think will really serve any purpose. Ultimately, if you look at globally, conduct of corporates can only be corrected if they have to be made to pay through their through their coffers. And I think that is a lesson which we need to imbibe. I think the CCPA under the consumer protection law needs to become really robust and strong. The issue really will be how to determine claims and compensation for losses, the whole process of reducing evidence as to who faced what kind of loss. But I think its time is ripe now that the authorities need to exercise the power that the statute has given them and really make corporates pay, errant corporates pay that have not followed the good behavior as the law requires them. That's the only way you'll be able to correct this malaise and make sure that the domestic market for pharma grows, healthcare grows, while making sure orderly conduct even by them. There are ultimately, let's not forget that pharma companies, wherever they've made wrong statements or there has been mis-selling, they are penalized. And I think there should be no immunity for any alternative form of medicine either.
Point well taken. You're almost out of time. I'll take one final comment from Malak Bhatt from NM Law Chambers. Malak, on the vaccine point that again came up in discussion, Ramdev made a lot of points on vaccines. That would have been okay, but he's talking of buying his own medicine, which is Coronil, and as one of our panelists now said, that hundreds of crores of business was done thereafter. I take it at another level. 70% of the WHO's vaccines are manufactured in India. India has a certain brand name to live up to. Is it fine for our own Indian people to run down the whole vaccine ecosystem? Given the fact that we have such a successful vaccine, people say that we are the vaccine capital of the world simply because we export so much. South Africa, Europe, so many markets vaccines from India go. In that perspective, how do you see this whole issue?
In fact, your core question has been answered by the court itself, because today you have the court through the two justices who have taken this issue up and are today telling the people at large that, look, this is not okay. And I think what the court has done is two very good things. Number one, it has instilled faith in the pharmaceutical industry at large to say that if there is going to be inaction on part of the authorities, or if there's going to be violation of laws which are in place to protect the manner in which the drugs are brought into the market and to safeguard public interest, the court is there to stand itself. If you remember, if we go back to the pandemic stage, there was a time when the corona vaccines could not be launched immediately because they had to run the phase 3. And there was a deliberation at one point by the government whether the phase 3 can be shelved or not. And the answer by the DGCA was no, you cannot. You have to go through the phase 3, and which is why the first stage of the vaccine was only for the frontline workers. As compared to that, you have an alternate medicine which does not go through any regulatory regime and stands out and says, look, I am better than anything else, is something which the court is today holding back. Through that same message, what the court is also saying is that is a message to the public at large that all is not okay by alternate medicine companies to say that we are the best and we are going to be curing all your diseases. And that's where the public is actually being informed that dissemination of each and every information is not going to be true. So you as the public at large have to be well aware, well informed, and for that the regulatory regime is in place. So yes, it is a message loud and clear to the pharmaceutical industry that the regulatory regime will be enforced, will be put in place, and will be effectively utilized through the court to ensure that the public safeguards are well met. Most importantly, as you said, we are today at one stage around the 90s, we were looked at a country which was only in applied sciences. We were not looked at as a country which was doing research, which was actually producing drugs. Since the 2010 phase, we have pharmaceutical industries which are manufacturing, researching, and using applied sciences to manufacture most of the drugs in India. And as you rightly pointed out, during the pandemic phase, you had India as the biggest exporter. So this, in fact, I would say is a good thrust that the court has given to ensure that the public is also informed about the fact that if they really have to pick their drugs, it is not just by way of advertisement, but by way of information which the agencies or with the authorities are putting out in place. So I think that is a message which has gone out well and loud and clear.
Thank you for that closing comment. I really appreciate both of you joining, and Justice Hima Kohli, Justice Ehsanuddin Amanullah, the Supreme Court for standing by the common Indian citizen who believes in so-called demigods, when they believe that belief has, in a sense, to be tested time and again, that it should not be used to pass on medicines which may harm these very people because they believe in a certain person. The Supreme Court has come to the rescue of such people. We all appreciate the efforts of the Supreme Court on this account. Thank Above Kamkar, Senior Partner, Seraphin Partners, Malak Bhatt, Founding Partner of NM Law Chambers. Appreciate your joining us. Thank you so very much.